Welcome to The Explainer. We're breaking down Arizona property ownership, a must-know for real estate agents.
So, what's the biggest legal hurdle for agents in Arizona? It all comes down to one thing: title.
Get this wrong and boom, bad contracts, messed up titles, and your clients could lose a ton of money.
So let's talk about vesting. That's just the fancy legal term for how someone actually owns property. All right, let's get into your toolkit. There are two basic ways your clients can co-own property here.
First up, tenancy in common. It's the default in Arizona. Think separate shares that go to their heirs.
And here's the big deal: their share has to go through the courts. That process is called probate.
Now, the other option is joint tenancy. This one has a superpower, the right of survivorship. It skips probate.
But there's a catch. This isn't automatic. You have to write specific words in the deed to create it. So here it is side by side. One road leads to court, the other completely bypasses it. Big difference.
Okay, now let's add a wrinkle: marriage. Because remember, Arizona is a community property state.
The law basically assumes anything bought during a marriage is owned 50-50. It's called community property. What does this mean for you? You need both signatures, period, even if only one name's on the title. Okay, this chart breaks it all down. These are your four main ways to co-own property in Arizona. And then there's this hybrid CPW ROS. It's kind of the best of both worlds for married couples here. All right, let's talk about two legal landmines. Knowing these will save you a world of trouble. First up, the disclaimer deed. This is what one spouse signs to say, I have no interest here. So they give up ownership, but the community might still have a claim to some of the money later on. That second landmine, probate. It's the court process that can stop a deal dead in its tracks for months. So remember, joint tenancy and CPW ROS are your probate avoidance tools. They're designed to skip all that. Okay, last section. And this is probably the most important part. What is your job in all this? The rules are crystal clear. Your job is to protect your client. That means disclosing everything important. And here's the bright line you can't cross. Explain the options, but never advise them on which to pick. Telling them how to take title, that's practicing law. Don't do it. Always send them to an attorney. So with every client from now on, you have to ask yourself this one simple question.